Welcome to the Fourth Circuit. Our first case will be United States versus Fulton. Ms. Englander.
Good morning, Your Honors. May it please the Court. My name is Kate Englander, and I represent the United States. A jury convicted Stephen Fulton. The trial court threw out that conviction based on a clear error of law and conditionally granted a new trial. This court should reinstate Mr. Fulton's conviction. Now, there are two issues here on appeal. The first is whether the judgment of acquittal was an error, and the second is whether the conditional grant of a new trial was an abuse of discretion. And I'll start with the first issue. The trial court erred when it concluded that the government had to prove to the jury the maximum penalties for Mr. Fulton's predicate conviction. This deals with the element that the government had to prove in this case that the defendant made a false statement on the ATF form in connection with his purchase of a firearm. And here the false statement was that he was not a felon. So in other words, the government had to prove that he was in fact a felon. And it did so. Now this is an element that has both a factual and a legal component to it. There's the factual component that the defendant, the person who was sitting in the courtroom, was the person convicted of that offense. That is what the government proved at trial through admission of the judgment of his prior conviction. The legal component of that question is whether that offense was a crime punishable by a term of imprisonment exceeding 1 year. And the government submits that that was for the court to determine as a matter of law, and that it was therefore error for the court to throw out the conviction based on the fact that the government did not put in evidence of the maximum penalties. Now, there are really two cases in this circuit that address this issue and sort of draw the distinction between the factual and the legal component of this element. And those cases.
I'm assuming you would say that the termination of a felony under 922G1 and the statute we have here at 922A6 would be the same.
That's right, Your Honor. I don't think that there's any real distinction in a case like this where the false statement is that the defendant wasn't a felon between the way you would determine that element of a 922G1 and this element of a 922A6.
So that would be a question of law under either statute.
Correct, and that's what other courts have said about that element of 922G1 very clearly.
Counsel, did you, as I understand it, at trial, the prior conviction was introduced, and there was a witness who was asked the question of whether or not it was punishable by more than 1 year, and that testimony was not allowed. Is that evidentiary decision before us? The district court's refusal to permit the witness to comment on that, or is that maybe it's just bound up that in this first issue you're talking about?
Thank you, Your Honor. So I don't think it's before the court in the sense that what the government is really asking for is just for the court to reinstate the conviction. So we're not actually contesting at this point that the court didn't give a certain instruction or that evidentiary ruling, but I do think it is bound up in that issue.
But it's interesting, though. I mean, why would you ask if you really think this is a question of law?
It's a good question, Your Honor. I'm not sure exactly why it was asked. I think the court was correct not to allow that testimony. I think it was a decision for the district court to make.
But the district court didn't deny it on that basis. The district court said this witness didn't have familiarity with whatever law was involved. So it was not a law versus fact denial. It was a you don't have enough information denial. And anyway, it seems like at least I understand the position that this is a question of law, but I just wonder about I don't know what to make of that, but it seemed like the government, at least below, was proceeding in a way to try to introduce it as a factual matter. And
I think what the district court said was, this person is not qualified as an expert on New Jersey law.
Right.
I'm not certain that the government, if it wanted to, could have put in an expert on law in a case like this. The district court is the expert on the law, and they make the rulings as a matter of law.
I think that's fair, but that's not how, I mean, you see my question, it doesn't look like that was the way it was litigated below.
I take the court's point that that's not how it proceeded at trial, but I also point out to the court that before the trial, the government did submit an instruction in its proposed jury instructions, and that's at JA 78, where it asked the court to instruct the jury as a matter of law, this conviction is punishable by, this offense, which was the conviction, is punishable by more than a year in prison. So I do think that, perhaps that there was an effort by the government at trial to get that in, but certainly the government viewed this.
Maybe the government was just rolling with the structure that the trial judge had set up through his comments and rulings.
I think that's very possible, Your Honor.
And they
but-
both may have been wrong. That's neither here nor there.
Point taken. But I do think, it's clear in this circuit that there's both a legal and a factual component to this. Essick illustrates that where there is a fact that the government needs to prove to the jury in order to prove that, that the crime is in fact punishable by more than a year in prison, that it needs to do so. And so in that case, the defendant had been sentenced, it was more than 6 years after his previous predicate conviction. And at the time, under North Carolina law, you could basically automatically get your civil rights reinstated after 5 years, unless there was sort of subject to some exception. So the government had an affirmative obligation in that case, what this court said, to prove that he had not had his civil rights reinstated. But in Thomas, this court then said, when it's less than 5 years and he couldn't have automatically had those rights reinstated, it's established as a matter of law that it was a crime punishable by more than a year in prison, and the government didn't have to make that additional factual proffer of evidence to the jury.
Are you aware of any court that has held that this question of whether a crime is punishable by more than a year in prison is a factual question for the jury?
I'm not, Your Honor. Every court that I'm aware of, and that includes decisions in the 1st, 5th, 6th, 8th, 10th, and 11th circuits, has held that it's a matter of law. The Third Circuit jury instructions also instruct the district court to instruct that it is a matter of law. And there's good reason for that, too. I mean, it does prevent the government from admitting evidence that could be prejudicial to the defendant. Convictions that wouldn't qualify really shouldn't be in front of the defendant. And the First Circuit is actually, at least one other circuit, have treated this as a threshold evidentiary issue for that reason. So I think there's good reason to think that that's the appropriate way to handle it. I would also just point out, following this court's decision in Simmons, we certainly don't ask juries to try to interpret the North Carolina structured sentencing to decide whether someone's predicate conviction is punishable by more than a year in prison, right? It's a complicated scheme that needs to be sorted out by the district court, not something for juries to decide.
What do you make of the Burroughs case that your colleague cites? I know that's different. It's federal jurisdiction. It's not this specific question. And the case is kind of strange. It doesn't do a whole lot. I don't know if but there's a footnote in there that suggests federal nexus might be a question for the jury, which seems maybe at odds with other cases. But do you have a view on that case?
Your Honor, I don't think it's applicable here for the reasons that the court cites. The fact that it deals with federal nexus, I don't have much beyond that to say on that issue. I think it's clear from the way other circuits have handled this, as well as the way that this circuit has handled this issue, that it should be decided as a matter of law. And there was an error for the court not to do so and to throw out the conviction on that basis.
Yeah, the only point would be to the extent that, federal jurisdiction is what might also be a question of law, or arguably is, and to the extent that case implies that's an issue for the jury, maybe it's not applicable in the sense of controlling, but does it give us an analogy? But anyway,
I think the closest analogy is certainly going to be Essex and Thomas
Right.
here. because they deal so directly with this, virtually the same element. And I think that those cases lay out clearly what the court's obligation was here, and that it was really error for, I mean, the jury clearly, by convicting, made a determination that the defendant had been convicted of that offense. That's the factual element, component of the element. And so it was error for the court to throw it out based on an incorrect assumption that the government had to prove more than that.
Can you move to the Rule 33 issue? Assume you're right on the first one, assume we agree with you. How is it an abuse of discretion for the district court to order a new trial under Rule 33?
Yes, so what this court said in Rafikian is that it's an abuse of discretion, it's error, if the court grants that new trial based on an erroneous factual or legal premise. And here, we think that the grant of the new trial flows directly from the error of law that the court made in thinking that the government had not proved the conviction.
Why is that?
So what the court,
Well, are you saying the error was failure to prove the conviction or failure to show that it was a felony?
yeah, I misspoke, Your Honor. Failure to prove that it was a crime punishable by more than a year in prison. So what the court said is because the government didn't prove that, necessarily the government couldn't have proved knowledge, couldn't have.
Where are you getting, I mean, I know that's what your brief says, and I just didn't see the district court tying the decision about knowledge to the absence of proof of a felony or punishable by more than 1 year.
I think the court doesn't highlight any errors in the trial other than that one error. And so really, I think that it's sort of a doubling down on the issue of the government didn't prove that he was, in fact, convicted of a crime punishable by more than a year in prison, then it couldn't have been knowing and it couldn't have been intended to or likely to deceive.
But that's not what he said. He said the judgment, or the judgment doesn't the issue is knowledge, and the judgment doesn't specify the information about how long it's punishable. And he says it was punishable, he only stayed in prison 13 days. And then he cites the testimony of Officer Cato. And look, I get the frustration, but it seems to me like he just exercises the right that rule gives, and says, you know, I just disagree, even though the jury could have come up with that conclusion.
I think in that case, Your Honor, it was a factual error about what was actually shown at trial. I think the court disregarded a lot of the evidence that the government put forward that it was in fact knowing. You know, first of all.
So
What
let me read
evidence?
you
I'm sorry, go ahead.
So this is JA 254, and he's announcing his decision on, this is in the written opinion, on a new trial. The court nonetheless determines that a new trial would be warranted in light of the absence of proof of Fulton's knowledge that the statement was false, which is a different issue in part as to whether or not he knew he was a felon. And by using the term felon, it's a shorthand for more than a year.
Right, but I think what the district court relied on there is the fact that the judgment didn't say felony, which in and of itself, you know.
Well, the proof that the statement was, that the felon knew the statement was false is a separate element. And even though the Supreme Court said, well, you know, a felon usually knows they're a felon, there are cases, particularly that involve state misdemeanors, where that could be an issue. Now, here I guess your argument could be that the district court was just factually wrong because there was testimony that Judge Quattlebaum referred to about his felon status. But it seems kind of murky that it went right back to the law versus fact question that you've already covered.
I think in part the court was relying on the fact that the defendant couldn't have had knowledge because his judgment didn't say felony on it. I think the jury, based on the sum total of the evidence offered at trial, clearly could have rejected that and determined that he did have the knowledge. As the court pointed out, the fact of conviction itself, as the Supreme Court has said, is powerful evidence of knowledge. But there was other circumstantial evidence offered at trial as well. The ATF made a visit to the defendant, well, a phone call and a visit to the defendant, during which they told him, you are a convicted felon, you need to stop trying to purchase firearms.
And did the district court weigh that? I saw the district court said, Agent Cato testified, but then when talking about the weight of the evidence, he didn't seem to factor that in, that I could tell, but what's your position?
That's right, that's our position, Your Honor, that he didn't, he sort of disregarded that evidence in his assessment.
Because it's one thing to say, well, you got 13 days and it doesn't say felony on it, but this gentleman got two personal, he got a phone call and a personal visit. They said, you are a felon, stop it.
Right, and that alone is powerful evidence as well. In addition to the felony, the fact that he was denied from buying a firearm, I believe 11 times.
So are we saying then that, he just needs to explain it more? I mean, because I don't dispute that there was evidence from which a jury could have concluded knowledge. I mean, I think you articulated some, and a jury could have done it. I guess my issue here is, what are we asking district courts to do? I mean, the rules permit that discretion, and anyway, is the abuse of discretion in your mind not articulating more about its reasoning in the weighing process?
I think the abuse of discretion is not weighing the evidence at all. I think that the abuse of discretion is the trial court trying to substitute its own judgment completely for the jury's in this case.
I thought you were going to argue that the abuse of discretion was the district court statement that there was an absence of proof of his knowledge, when clearly there is knowledge in the record. So for the jury to weigh, but if the district court made that factual error, is that an abuse of discretion?
Yes. That is an abuse of discretion here, where there was, again, significant evidence in front of the jury as to both the knowingly and intended or likely to deceive elements. And moving just briefly to intended or likely to deceive, in its written ruling, the court only addressed one of those two prongs, but I would just note that the government could have proved it either way and did, in fact, prove both intent to deceive and likely to deceive. This court has...
You're a little over, so
Oh,
you've got
I
some
apologize.
time on rebuttal.
Thank you, Your Honor.
Ms. Tarleton, we'll be hearing from you.
Good morning, Your Honors, and may it please the court. I apologize for my cough drop. This court will only reverse a judgment of acquittal if there is substantial evidence to support the jury verdict. I think it's important to recognize what my friend is asking for is reinstatement of a jury verdict on which there was no evidence presented at trial and, in fact, no instruction given to the jury as a matter of law. So this jury...
As to what issue?
As to the punishments for the New Jersey conviction that Mr. Fulton had sustained. So if the government argues it's a question of law...
So you're arguing that's a question of fact?
No, Your Honor. I think there's a lot of ambiguity in this record. I take from the court's questions an assumption that this is a question of law, but even if that is true, the judge would have needed to instruct the jury, this is a crime punishable by more than a year under New Jersey law. He refused to do that, and the government in this appeal did not challenge the denial of that requested jury instruction. And so as it stands, there was nothing on the basis of which this jury...
Wasn't there a predecedent error, though, that if the district judge was under the view, apparently shared only by him and no other court, that the issue under A20 and G1, and for, I would assume this statute here, that it's a question of law once the conviction has been entered of the record, and the law determination is to be made by the judge. I mean, if he started with that error, why isn't that enough?
I think there was some back and forth between the judge and the government about whether this was a legal or a factual question, but the judge reserved ruling on the Rule 29 at the close of the government's case, and at that point the government hadn't even put in the statutory penalties in New Jersey. So they hadn't even given the judge the predicates to make a legal determination upon which to instruct
Well,
the
if you
jury.
knew what the statute was, I mean, he's got law clerks, they can look that up, he can look it up. Why did they need to do that?
Well, Your Honor, I think there has to be an adequate foundation for especially an out-of-state judge to be making this determination. And I think we can see that based on this court's en banc decision in Simmons. These can be complex questions. I don't think a judge would want to, in the last few minutes before jury instructions are entered, make a complex determination about statutory penalties where, for example, in Simmons, this court has held you can't take the statute at face
Yeah, but
value.
we have cases almost every day in the criminal sentencing context. And the issue is, well, was it a crime of violence, an aggravated felony, and we're looking at prior convictions in state courts. And once you know what the statute is, the judges do that work.
Sure, Your Honor, but even in that context, the government did not appeal the district court's refusal to give their requested jury instruction. And as that stands, this jury verdict is fundamentally defective.
Would it have to be done that way? I mean, I grant you that's one way you could do it, with a jury instruction that says what the punishment is. But once the judgment is entered, is there anything wrong with the district court determining this is a legal issue? I can tell the law that it's punishable by more than 1 year. Does that actually have to be carried out through a jury instruction?
I think so, Your Honor, and I think this court's decision that you pointed to a moment ago in Burroughs is instructive on that point. Footnote 7 talks about how this court will not take judicial notice on appeal of an unproven essential element of a criminal offense, because the jury was not instructed as to the necessity of finding a federal nexus, and we cannot assume that the jury would have arrived at the same verdict.
That's a footnote, and I hear you. I asked the question about it. I think that's probably the best you got, quite frankly. And you know, most of Supreme Court and Fourth Circuit law talks about federal jurisdiction being a question of law. I mean, that goes back to the 1800s. I've just looked at that in another matter. So I don't think Burroughs really could fairly say the Fourth Circuit views federal jurisdiction issues to be the province of the jury. So I think, yeah. So anyway, if Burroughs is your case, that's I understand that, but I'm still having trouble with the notion that it has to be done through a jury charge. That could be done, but I don't know why the court couldn't just exercise its province as the expert on the law to do that.
Well, I think, Your Honor, this is a situation, first of all, I don't think that the penalties for the New Jersey statute are a question of federal jurisdiction. And I think that
I couldn't hear what you said, something about, just repeat what you said, I couldn't hear you.
yes, I don't believe that the statutory penalties for a New Jersey offense are a question of federal jurisdiction.
Sure.
And I also think that the judge, in this case, Your Honor, Judge Agee had brought up the question of, is this the same as 922G? And I think in some ways it is, and in some ways it isn't. Like in 922G, that prior felony conviction is itself the element. Here, it's a little more complicated because the question is whether the statement was false.
The definition of the term is under A20, I think, for both statutes, isn't it?
That's right.
And we have cases that say directly that the meaning under A20 and G1 is a question of law, period.
Yes, and even so, Your Honor, there was nothing before this jury. No evidence, no jury instruction, nothing. And so if this court were simply to remand, to reinstate the guilty verdict
But
issued by the
again,
jury.
And I don't want to belabor the point, but we often have situations where the jury is asked the questions of fact, and then the judge decides the law and marries those two things up. The jury's not always instructed on the law says X, Y, and Z if it's not pertinent to a finding they have to make. So why does it matter whether there is a jury instruction? I understood your argument to be this is a question of fact, not law, but now you're saying, well, even if it's a question of law, it's somehow not preserved because the judge didn't tell the jury about the law? But if they didn't have to find it, I'm not following why that matters.
So here, the element that's relevant in 922A6 is whether the statement that Mr. Fulton made on the form was false. So there is a finding that the jury has to make based on the understanding whether or not this is a felony under New Jersey law.
Well, they have to say he was convicted. This is the guy, we have this judgment, that's the same man. He was convicted of this crime, and he said he wasn't, right? And he knew, and, you know, all the other elements, he knew that he was. But whether that crime is punishable by more than 1 year is a question of law. The judge doesn't need fact findings. He doesn't need judicial notice or any of that. He can go look up the law and figure it out.
Sure, but then the jury is tasked with determining whether then the mismatch between what Mr. Fulton said on the form and what the statutory penalties in New Jersey are constitutes a false statement. That's the question that's for their consideration under 922A6. And so I think given the fact that they were not properly instructed in this case and given no foundation to make that determination, I don't think that this court could fairly say that there is, quote, substantial evidence to support the jury verdict.
So they had no foundation to decide what exactly?
The falsity of the statement that Mr. Fulton made, because they were not instructed nor provided any evidence about the
About whether he
penalties
was
under.
a felon or not?
That's right.
I thought somebody got on the stand and said he's a felon, and I told him he was a felon twice.
Agent Cato testified that he told Mr. Fulton twice that he was a felon. He never testified that he told Mr. Fulton he was convicted of a crime punishable by more than a year, and some felonies are not qualifying under federal sentencing law, as this court is well aware. But in any event, Judge Boyle rejected the government's attempt to have Agent Cato testify about the statutory penalties.
Because he wasn't a
saying-
legal scholar.
Because he was not qualified under, to testify about New Jersey
About the law.
penalties. And the government confirmed today that they're not challenging that evidentiary ruling. So it would be challenging for the court to say, well, you can prove his
But
knowledge.
again, you had a predecedent error. I mean, the only reason that the agent was asked those questions to testify was to get before the court in its incorrect view that it needed some evidence of what the New Jersey penalty was. And then once you had the order entered, if the judge at that point was to determine the law, this is a felony, and again, I'm using felony as a shorthand, you already had that pre-existing error before the ATF agent got up there.
I don't think that's supported on this record, Your Honor. There was no conversation about whether this was a factual or a legal question prior to Agent Cato's testimony. After Agent Cato's testimony was
Well, I certainly
concluded.
saw a number of places where the government was arguing at trial. This is a question of law, Your Honor. This is for you to decide.
None of that started until after the close of the government's evidence. And under Rule 29B, the rule provides that when the judgment on the judgment of acquittal is made and reserved, that's when the record closes for that determination. So if the court reserves decision, it must decide the motion on the basis of the evidence at the time the ruling was reserved.
But that, is that really, maybe it was just the same question, but yeah, I mean, the evidence in the record is the judgment of and the statutory basis of the conviction. I mean, the government's position is we don't need more evidence. We've got the evidence. What we need is the legal decision as to whether that crime is punishable by more than 1 year. That's a question of law. So anyway, I'm not sure I'm following why, there's more evidence needed if it's a legal question.
Well, just to clarify, Your Honor, the statute had not been provided either to the jury or to the judge at the time the government closed their case or at the time the Rule 29 was initially
The
raised.
statute's not on the judgment?
No, it's not. Well, the statutory cite is on the judgment, the statute of conviction. But
That's
New
what I
Jersey
meant.
actually keeps their penalties in a separate provision, so it's not referenced on the New Jersey judgment itself. And a lot that from
So
the,
the
And now-
judge's law clerk would have gone right to that.
perhaps, Your Honor, but my point was just to say, as a matter of chronology, the government had no indication from the court at that point that it believed that it was a factual issue, and so there would have been no signaling from the court that would have encouraged the government to ask those questions. That was done on the government's own initiative for whatever reasons it may have had.
And why does it matter? You said there was nothing presented yet on the substance of this New Jersey law. Why does that matter?
Because at the time judgment was reserved on the Rule 29 motion, that's what was before the court, just this bare conviction. And so even if that was enough, if this court believes that that was enough as a matter of law to make that determination, I believe there was still a requirement that the judge properly instruct the jury to say this is a crime punishable by more than a year. And without that instruction or any other competent evidence, there's nothing on which this court can reinstate the judgment. And so we think
So that's just back to the, is this a matter of evidence or is this a matter of law?
Well, I think, Your Honor, even if it's a matter of law, there has to be an instruction to the jury about the question of law, where it's baked into this bigger question about falsity of the statement. It's not just that that finding by the, or that legal determination by the judge would be sufficient to check the box on that element. And Burroughs, I think, speaks to a wariness on the part of this court or even a district court acting after a jury verdict to supplant,
Maybe
you know, what they.
I'm just not following your argument, but it seems like to me that it reduces to, well, the judge made an error because he did not make a determination of law, and because of that error, he didn't instruct the jury, and because he didn't instruct the jury, then his decision should be affirmed.
I think even if not affirmed, this should at the very least be sent back for a new trial, because I don't think that reinstating the judgment in this context is appropriate because there was a flaw in the jury instructions. And so there was nothing on which, there's nothing in the record below that would support the substantial evidence that on the jury verdict about the false statement, because that's just lacking on this record. So we would ask the court to remand for a new trial. I wanted to say briefly on the question of knowledge, just that there's this inconsistency between Agent Cato not being allowed to testify on the penalties and somehow using his statements to Mr. Fulton to charge him with knowledge that he was a felon. Ordinarily, in these kinds of cases, the government introduces a plea colloquy from the prior conviction, which addresses both of these questions, and so it never has to come up. There you would establish both the statutory penalties that apply and also the defendant's awareness of those penalties. The government elected, for whatever reason, not to do that here. And so the only evidence that they put on of knowledge was this statement by Agent Cato in his testimony. And the government, like I said, has not challenged and confirms today that they're not challenging the court's refusal to allow him to testify because of his lack of expertise in New Jersey law. This is a task force officer based in
Could the jury have
Goldsboro.
inferred, and I can't remember now at what point this evidence came in, that the defendant in this, Mr. Fulton, this was his 10th or 11th venture out to a gun dealer, and each time he got rejected, and I mean, could the jury have inferred from that he was rejected all those times because he was disqualified as a felon?
No, Your Honor, for two reasons. One is that when the NICS system reports back a result to the sales clerk at a gun store, they are not told the reason for the denial. And so there's no way that a sales clerk would have known to inform Mr. Fulton that he was denied because of a prior conviction. What is more, I will say that as a public defender, most of our cases involve guns, and I can't recall a single other case where a client tried to go into a brick and mortar gun store. So I think his repeated attempts to acquire a firearm lawfully are actually powerful evidence that he did not believe that he was a prohibited person under the law.
That kind of strikes me as just like the argument on the other side. You know, you can argue to the jury that someone who has been convicted, which the Supreme Court says is in itself powerful evidence that someone knows that they are a felon. You know, one side could argue all these repeated denials surely reminded him or reinforced to him that he is prohibited from owning a firearm for this reason. And then the other side can argue, oh, but he tried to obtain one legally. Surely that suggests he didn't know, right? But that those are factual arguments for the jury to weigh, and maybe the jury credited, I mean, they convicted him, so they credited one over the other. I don't see why that's an argument that that's not evidence that the jury could find, from which the jury could find knowledge.
I think both of those things were in the record. So we
Right.
had both his repeated attempts and also the fact that the report that goes to the sales clerk does not inform them
Right.
of the reason for the denial.
But we let the jury draw inferences from circumstantial evidence. They don't have to have, you know, a written report saying he was denied because he is a felon for the jury to conclude that that's enough to convince them that he knew what he was saying was false.
I would also note in the vast majority of other cases, there is introduction of the plea colloquy. Sometimes there's evidence that the particular defendant had seen the judgment that's introduced. None of that happened here. And from the four corners of the judgment in any case, the word felony is never used. The penalty he received was only 13 days time served plus 2 years of probation. And there was no reference to the applicable penalties for Mr. Fulton to have seen or absorbed. He also, when Agent Fulton said that he was a felon, came back saying, not, I understand, yes, I agree with you. He said, I have a meeting with the government. And who knows what to draw from that. But it's not an admission by Mr. Fulton that he knew he was a felon. So we would ask this court certainly not to reinstate the guilty verdict, but at most to remand for a new trial.
All right, thank you very much. Ms. Englander, you've got some rebuttal time.
Thank you, Your Honors, and I apologize for going over last time. I didn't realize it was counting up and not down, so I'll try to be shorter here. First, I just want to respond to the point. There does not have to be a jury charge on this question. I would point this court to the Eighth Circuit's decision, United States versus Jenkins. In that case, the government introduced a conviction document that said that the conviction was a Class 3 felony. The jury came back with a question about what were the maximum penalties for that. The judge then instructed, because the judge said this is a matter of law. So certainly it could be done that way as well. It is a question of law. It didn't need to go to the jury in that way. Certainly it was the government's preference that that instruction be given. That's why we submitted it. But what happened here is that the government proved the factual element, the jury convicted, and that is sufficient in the government's view to reinstate the conviction on that basis. Second, I just want to address the issue about the introduction of the plea colloquy that my colleague on the other side referenced. So in our view, if the government had introduced a plea colloquy from that the prior conviction, that would have gone to the defendant's knowledge, certainly. It would have been one way to prove it. It's not the only way to prove it, and the government put in other evidence that the defendant knew that he was a convicted felon. But that still would not absolve the district court of its obligation to make the decision as a matter of law whether that conviction was in fact punishable by more than a year in prison. So the fact that the other court might have read, the court in New Jersey might have read statutory penalties, that is itself doesn't, that would be evidence of knowledge, but it doesn't necessarily go to what the court still needed to decide here.
Yeah, your colleague's argument is maybe a little different than I thought it was going to be too, but as I understand it, that the argument is, moving away from whether it's a question of fact, but how could the jury decide the statement was false if something before it didn't say the crime was punishable by more than 1 year? So is there any basis without a jury? It may be that the judge can decide as a matter of law that the statute is punishable by more than 1 year. But the jury's got to decide it's false, and it can only say it's false if it has something that says it's punishable by more than 1 year. And what is that in this case if it wasn't a jury instruction? Sure.
So Agent Cato did testify that the defendant's conviction was a felony. So that was before the jury. The jury had, and then the jury again had the judgment which showed that he'd been convicted of that crime. It also, so I think the jury had enough to decide the factual component of that element that it needed to decide, and it did make that decision when it rendered the verdict. And it would be the government's position then that as a matter of the fact that, there was perhaps an error in the instruction, that would still be just a matter of law. And so for that reason, this court should reinstate the jury's conviction. Unless there are any other questions, I'll just ask that.
All right, thank you
Thank
very
you.
much, counsel. We'll come down and greet counsel and then move on to our next case.
May it please the court, my name is Valerie Bateman, along with my co-counsel Heather Benjamin and our law firm, New South Law Firm. We represent the plaintiff appellants in this matter, Patsy Talley, and other individuals similarly situated to her. In this case, the underlying facts are important. Ms. Talley and the other individuals were receiving government benefits. Ms. Talley and Ms. Glenn, or her husband, were receiving retirement benefits, and Ms. McCracken and Ms. Stickle were receiving disability benefits. Everything was fine. They were going on receiving these benefits based on the state's representation to them of the amounts that they were owed, until one day they received a letter in the mail. And that letter said, "You owe us possibly tens or thousands of dollars in overpayments." And that's when this case began.
So
Yeah.
are there other plaintiffs in this case besides Ms. Talley?
I'm sorry, Your Honor.
Are there other plaintiffs in this case besides Ms. Talley?
Ms. Talley was the named plaintiff in the original complaint, and then a motion to amend the complaint was filed to add Ms. McCracken, Ms. Stickle, and Ms. Glenn.
And that motion was denied, correct?
That motion was denied in conjunction with a final order in this case, in which the court dismissed the remaining issue in the complaint, the procedural due process issue, on a motion for judgment on the pleadings.
All right.
Okay. Ms. Talley was informed that she owed $86,000 in overpayments. In the joint appendix, the letter to her appears on page 61, and it states your overpayment balance as of 3/19/2019 is $86,173.93. Effective with your April 2019 payment, our office will begin monthly deductions of $926.35 to be applied to the overpayment balance. This is key. If we may be of further assistance, please contact us at the address or telephone number listed below.
So what does your client say that she owes, if anything?
I'm sorry, Your Honor.
What does your client say she owes, if anything?
My client says she's not sure what she owes, but she has not had an opportunity to contest the amount, and she was not provided any process. She was never offered an opportunity to be heard on the amount before the state started taking these amounts out of her check.
Can I follow up on that? Because I wanted to ask about your procedural due process claim. So she's not contesting, at least in the procedural due process claim, the collection of the money itself. It's the collection of the money without process. Is Is that right?
Yes, Your Honor, it's the collection, it's the lack of due process prior to just taking the money from her.
And so then she had an administrative hearing, is that right, later, once they started taking the money out?
She did.
And received process there, and you're not challenging that process, is that right?
Well, we're challenging that process insofar as it's a post-deprivation
Right.
hearing at which we could not raise any constitutional issues. And we could not raise the fact that she had not gotten any pre-deprivation due process. Let me just say this.
So I just want to clarify, because understanding this is, I think, helpful for sorting out some of the district court's rulings. So in the complaint, you've challenged collecting the money without process. I think that is a due process violation. Now, she received some process later, and that doesn't cure the problem, but she received some process later, and collection after that process is not what you're challenging, right? That's flowing from that's flowing from the process she got.
We are challenging and would have challenged in the underlying case had our substantive due process and equal protection claims.
Yes, but in the procedural due process claim, that's challenging collecting without any process beforehand.
Yes, Your Honor, that's exactly right.
So the injury for that is you collected without any process beforehand, and that injury has already happened. That injury is not going on now.
It is going on now. It's ongoing every month. They are taking money from her check every month.
But I thought we just agreed she received process after.
She received an adequate process, but they're collecting it, and collecting it is arbitrary and capricious. Collecting it from her under her particular circumstances, in the amount they're collecting it is arbitrary and capricious. It's a violation of her substantive process rights.
Yes, but that's not your procedural due process.
That's correct.
Okay.
Yes.
That's just challenging taking it without any process on the front end.
Correct, Your Honor. But the substantive process and the equal protection claims dealt with the actual collection of the money itself. Because, let me skip to the qualified immunity argument, because that's the.
Well, before you go there, after Ms. Talley arguably received due process, after the recoupment process began, there was an administrative hearing.
There was an administrative hearing, but the problem with that hearing is that she was not permitted to show any basis for not collecting the money. What the state has argued is that it has no discretion whatsoever about whether to collect.
All right. At that point, did you have the availability of an appeal to a state court?
We did, but we didn't have a basis the only appeal we could have taken is one that says the administrative law judge didn't decide the constitutional issue and didn't decide the issue of whether the agency had to show some non-arbitrary reason to collect all of this money as opposed to a portion of it or forgive it.
So, but why couldn't you have raised all the issues you raised now before a state court after the administrative law?
Well, if you look at the state decisions, they have not none of them have dealt with the constitutional due process issue. And so we did not feel like that, we felt like the decisions, the precedent, the state court precedents would not be interpreting our arguments we thought the federal court was the best place to get a federal interpretation of what federal due process was required.
Well, we have lots of places in the law where we look, for lack of a better word, to exhaustion of remedies. If you had a remedy in the state court, even if you might have lost, I'm not sure why you would not have pursued that and why you weren't required to at least try that.
Well, we don't believe we had a remedy in state court, Your Honor, because the state courts are deciding the meaning of the federal constitution, and the administrative law judge in that case declined to decide the federal constitutional issue.
Well, wouldn't you have made the claim that that was error?
We could have made a claim that was error, but there's lots of precedent in state court that says, yes, the jurisdiction of the Office of Administrative Hearings
Yeah,
is
but
limited.
we don't have a state court decision in your case that says any of that.
Well, no, we don't, Your Honor, but if we had taken that appeal that would have had res judicata collateral estoppel effect on our ability to pursue our remedies in federal court. So it was better. Section 1983 does not require us to go through the administrative remedies available to us in state court and then judicial review of an administrative decision. Section 1983 permits us to bring our constitutional claims directly to the district court for trial and to this court. And the problem here is that we got no trial, and the district court never decided whether the process given Ms. Talley was sufficient. And that's really the issue we believe should be sent back to the district court, is to make findings of fact on the notice and the opportunity to be heard offered her, because our contention is that there was none. If you look at the joint appendix and you look at the notice that Ms. Talley got, Ms. Talley was only ever told, and Ms. Talley and all of the other individuals are only ever told, we're going to take this money from you. You owe us this money and we're going to take it from you. They are never affirmatively offered any opportunity to be heard. The only reason Ms. Talley even got her post-deprivation hearing in this case is because she had a lawyer who pushed for that. And then the agency finally said, okay, we're going to issue a final agency decision. Once they issue a, quote, final agency decision, then you can file your case in OAH. None of the other individuals ever got that far because they didn't have a lawyer and nobody pushed for a final decision.
So is that your equal protection claim, that some people who have lawyers and push harder get better treatment for this recoupment than those that don't?
That's part of it, Your Honor. The other part of it is that in the limited discovery we were able to get in the Office of Administrative Hearings, they produced a list of people and the amounts of recoupment that they do vary greatly in percentages. And it's not clear why some people only are required to give up 10% and some people are only required to give up 50%. And that's if they continue to have money coming in from the state.
But under that, either one of those arguments, Ms. Talley got the better treatment compared to others, correct? She had a lawyer and pushed it, so she was on the good side of any disparate treatment. And she also only had, at least after the initial reduction, they reduced it to 10%, so she would be on the better end of the percentage recouped, correct?
That's correct, Your Honor. I would say with this caveat, initially they told Ms. Talley, you know, we can take 100% of your retirement income.
Right, but are you aware of any authority from an equal protection standpoint that the person who gets the better treatment as opposed to the worse treatment has an equal protection claim?
No, Your Honor, but I will tell you that the other three plaintiffs, even though the motion to amend was denied, did not get the better treatment. And so they have, I would say at least they have viable equal
That might be a
protection
claim
claims.
they have, is what you're saying?
Yes, Your Honor. Also, though, the whole
Of course,
process.
we don't know whether whether they're parties before the court now or not.
I'm sorry, Your Honor.
We don't know whether those other plaintiffs are parties that are before us now or not. That depends on whether or not
Well, we did
the
appeal.
order entered denying the motion to amend is appropriate.
We don't know that. We did say it was not appropriate. We did appeal the denial of the motion to amend.
Right, I know you did. The district court said, well, one of the reasons I'm doing this is you were late. We had a scheduling order, you missed it, you were several months late in doing that, and you haven't given us a good cause, haven't given the district court a good cause explanation as to why you were late.
Yes, Your Honor. I will say this. Even if that motion to amend is not found to be erroneous, these three plaintiffs can still file a claim today. So the matter is not
But
going.
they're not before us now.
Yes, it's not before you now. But the equal protection issue not only pertains to the way in which people are treated, it pertains to the fact that there is an absolute lack of any procedure saying to people how they're going to be treated and how these amounts are going to be calculated, which really dovetails into the substantive due process issue
I was going
about.
to say that sounds more like a due process argument than an equal
I'm sorry,
That sounds more like a due process argument than an equal protection argument.
a substantive due process argument, an arbitrary and capricious argument, that the state is acting arbitrarily and capriciously and not having any rules that govern the whole recoupment process. If the court's interested, I will be glad to talk about why the qualified immunity argument used to dismiss the complaint was erroneous. The court relied on Swanson, and Swanson is a case that dealt with a revenue, change in the revenue statute and a decision by the United States Supreme Court, which came down 2 weeks later. The plaintiffs in that case filed a lawsuit under Section 1983, and the court said there was no clearly established law. That's very different from the facts in this case governing procedural due process, because those cases are, they go back to 1951, where the United States Supreme Court said in Mullane that the opportunity to be heard is the hallmark of due process.
But what's the most factually analogous case you have that says that the right you assert to have been violated is clearly established? If you could
Well,
just give me the case.
Do you want factually or legally?
I just want the name of the case.
I'm torn between 2 cases, Your
You
Honor.
can give them to me both.
Todman and Snyder.
Excuse me?
Todman,
Okay.
this court's decision in Todman,
Okay.
and Snyder. But I also think Presley is very instructive, too. It's hard to choose between those 3 cases.
Okay, thank you.
The law was clearly established in Mullane, in Goldberg, in Matthews versus Eldridge, in Atkins versus Parker. The law in North Carolina, it was also clearly established in Bailey, where the North Carolina Supreme Court said that these kind of benefits are property rights. In 2020,
So how does that clearly establish that if the retirement authorities have a statute that says we're to recoup money that was improperly paid, and they're directed to do that, and they're following that statute, even if the statute is determined to be wrong for the reasons that you raise, why is that clearly established to them?
because this, first of all, the statutes, it's clearly established that under the facts here, where you're collecting recoupments of government benefits, that notice and an opportunity is required to be provided. But it's also clear, it's also the statutes that the court relied on and the appellees rely on to say that they have to recoup these. They say we have to recoup these and we're not required to provide due process. And in the, these statutes, first of all, don't say that. And second of all, Todman, the court has said that, and it was exactly the same argument.
Wrap up if you can, because you're.
I'm sorry?
Wrap up if you can, because you're over time.
Okay, thank you, Your Honor. In Todman, the court says if the state judiciary is not providing sufficient notice of the city's ordinance, the city must step in to provide that notice if it wants its ordinance to survive a due process challenge. It's the same issue here. What the state cannot do is evade the requirements of the due process clause by throwing up its hands and say, we don't make the notice for
So
them.
is qualified immunity at issue in that case?
Yes, qualified immunity is the reason why the district court dismissed the last procedural due process claim.
No, I mean, in the one you were just reciting, is that a qualified immunity case?
No, Your Honor, that's not a
Right.
that's Todman. But the statutes in this case say that the recoveries can only be recouped to the extent allowed by law, that the state has to use lawful means, and in fact, in one of the statutes, it says the state's limited if
Counsel,
they
you've
sue.
got some time left on rebuttal, but we've let you go over several minutes.
I have 2 minutes and 26 seconds left? No?
No,
Am I
you're
misreading?
over.
Oh, I'm over. Oh, I'm sorry, Your Honor. Thank you. It's been a while since I've been here. Thank you very much.
All right. We'll now hear on behalf of the appellee, and I'm not going to attempt your name. Why don't you tell us what it is?
Thank you, Your Honor. May it please the court, my name is Olga Vysotskaya de Brito, and my colleague Mary Scruggs, Special Deputy Attorney General, and I are honored to represent the North Carolina teachers and state employees retirement system. I would like to jump right into the colloquy that I have heard court have with opposing counsel about the due process, procedural due process specifically, that has occurred here. And I think both Judge Rushing and Judge Agee asked questions about the post-deprivation remedies that was provided to plaintiff in this case. And the remedy was provided under Chapter 150B of the North Carolina General Statutes. It's a process at the Office of the Administrative Hearings. That decision was issued concerning these recoupments that the retirement system attempted to recover from plaintiff. And the decision affirmed the validity of the recoupment process that was used. It is now an established set of facts that the amount of recoupment was correct, and that's Joint Appendix pages 62 through 67, and that the process that was used by the retirement system was correct.
So is it your view that Ms. Talley does not contest the amount of the overpayment now?
Absolutely, and Joint Appendix against pages 62 through 67, uncontested findings of fact from the Office of Administrative Hearing that confirmed that the system overpaid $86,000, and that confirmed the process of recoupment that was being used by the retirement system was correct. Now, the questions were also asked about, and my opposing...
So if she wanted to contest that amount, is it your view that she would have been required to seek an appeal to the whatever state court there would be that would hear an administrative appeal?
Actually, Your Honor, that contestation could have taken place within the Office of Administrative Hearings. Plaintiffs are allowed to present expert testimony. Plaintiffs are allowed to give their own testimony about the recovery or about the payments. So all of that could have played out at the Office of Administrative Hearings.
Right, but once the administrative law judge makes a decision and says, all right, you owe $86,000, and the recipient beneficiary says, no, I still disagree, I only owe $10,000. What's their remedy at that point? They think that decision was wrong.
Yes, so the remedy is to appeal it through a petition for judicial review under Chapter 150B to the Superior Court in North Carolina, and then next steps would be appealing that decision if plaintiffs still disagree to the Court of Appeals, and then to the Supreme Court on discretionary review possibly too. And one of the issues that the opposing counsel has raised is that constitutionality, the due process, for example, could not have been considered by the administrative forum. However, Wilson County Board of Education case that we cited in our brief is clear that once plaintiffs appeals the decision from the Office of Administrative Hearings to the Superior Court is free to decide the constitutionality issues. And the state courts in North Carolina have decided 1983 claims before. So there was a complete remedy that included potentiality of an appeal on a constitutional issue that was available to plaintiff. Plaintiffs elected not to pursue it. So plaintiff should not be allowed now to bring this claim to this court because that remedy was simply not pursued by her. Talking about the post-deprivation remedy that the state has provided to
I think
plaintiff.
her response to that was, well, this is a 1983 claim, I can bring it in federal court if I want, I'm not required to pursue any state remedies.
Generally, that would be correct, except the administrative, generally you could sue, you could select your forum. You could sue in state court or you could sue in a federal court. Here, plaintiffs did sue in the administrative forum and had an opportunity to pursue that claim further up the chain through the judicial remedies available in the Superior Court and the Court of Appeals and state courts. So
is it your argument that because Ms. Talley didn't appeal to the North Carolina State Court, she's not exhausted her remedies and can't bring this case?
our argument is different. It's not centering on exhaustion. It
Right.
just shows, it goes to the heart of the procedural due process argument, and because that remedy was available to her.
You're saying all that indicates the process that's available to someone who
That's
has a
exactly right.
grievance on this issue?
That's exactly right. And because it was available to her, the state has satisfied the procedural due process requirement. The minimum constitutional requirements for procedural due process are satisfied. But I also wanted to guide the court to an issue about a very extensive attempt in this case that the state has made to reach out to Ms. Talley before the deprivation has occurred. Some of it is before you in a joint appendix, but some of it was not included in a joint appendix, but we cited to it in our brief, and it's docket entry 4-3, which is part of the retirement system's retirement file that Ms. Talley had, and it was attached to her complaint to federal court, so court had that record in front of it. There were multiple efforts that the retirement system has made to inform Ms. Talley, first of all, of the forthcoming recoupments and the errors that occurred, starting from August 2018, and that's page 3 and 4 of docket entry 4-3 before the court. There was a written correspondence informing of the error and that her file being reviewed. There was also a written correspondence from the system in November 2018. That's many months before the recoupment first started, saying that her retirement account was being reviewed, providing a phone number for a representative from the retirement system for Ms. Talley to reach out to discuss her options. Then in March of 2019, still multiple months beforehand, there were multiple telephone calls placed to Ms. Talley from one of the representatives of the retirement system, again, in an effort to discuss recoupment options. And then multiple written correspondence was mailed before the first recoupment started on April 25. Before the recoupment started, the state actually also provided an informal agency review and issued a lengthy letter, 6-page letter, explaining what happened, showing the calculations of the overpayments. That's district entry 4-3, pages 21 through 25. That letter is there. And again, inviting Ms. Talley to reach out to discuss the options. That conversation about discussing options did not happen until later in August, at which point the state reduced the original recoupment.
So that your arguments, counsel, here are that there was adequate pre-deprivation process, which the district court, found to the contrary and decided nevertheless on qualified immunity.
Right.
So is this argument, I'm just trying to think how it fits in. I understand what you're saying. My question, though, is you didn't cross appeal, did you, the district court's findings? So you're not really appealing that. You're just saying it sounds like that under qualified immunity, you can decide this on prong 1 or prong 2. This seems like a prong 1 argument.
Your Honor, we are the appellee here, and we are asking for the judgment to be affirmed. And as we understand these precedents, these courts' precedent, appellees could argue for other reasons that appear in the record in affirmation of the judgment. Okay. So there are multiple reasons on which you could affirm this court's decision, even if the court got the pre-deprivation remedy wrong, which we argue it did, that a sound deprivation remedy was provided. This court could affirm on that basis. For purposes of procedural due process, we think under Matthews and under McClelland precedents in this court, pre-deprivation combined with post-deprivation remedy requires a dismissal of the procedural due process claim.
So if I'm understanding what you've been arguing the last few minutes, is you correct me if I'm stating your argument incorrectly, that there's evidence in the record that the district court did not consider or did not document in its order that outlines additional pre-deprivation due process. Is that what you were arguing?
That's what we are arguing, and we are
Okay.
arguing
Right.
that the court also misunderstood the kind of remedy in total that the state provided. But yes, Your Honor, in short,
So if
that is the
if
argument.
that argument were accepted and it were found as a matter of law that all that together was adequate pre-deprivation due process, then we wouldn't get to a qualified immunity argument.
You do not need to get to that
Okay.
argument.
I just want to make sure I understood your argument. Okay.
That's right. We do think that the qualified immunity argument is also appropriate, but you don't need to get there. It could be affirmed on the basis that there was no appropriately stated procedural due process claim. I also wanted to get to a point that Judge Rushing has raised with opposing counsel about what was the ongoing violation at the time when this lawsuit was filed under Ex parte Young. Because what we have here are the board members sued in their individual and official capacities under Section 1983. And that requires a live, ongoing constitutional violation at the time of the institution of a lawsuit. At the time this lawsuit has been filed, the post-deprivation remedy was provided 2 years before the filing of the lawsuit. So we think the district court was correct when it determined that there was no ongoing violation and on that basis dismissed.
Just to make sure I understand the record, the administrative law hearing was 2 years before the current suit was filed.
That's correct, Your Honor.
Okay.
The decision in the administrative law hearing was reached, I believe, in February of 2020. This lawsuit has not been filed until 2022. And that should be your joint appendix, page 67, I think, with the date of that decision. But that, if the court were to agree with our argument that there was no ongoing violation by the time this federal lawsuit was filed, all of the claims that plaintiff is raising would go away based on that rationale. Substantive due process, procedural due process, and equal protection violation as well.
So accepting that, would the, I understand that point on the Ex parte Young, but except if you're right there, would the plaintiff have a claim for any recoupment that was done prior to that hearing?
Would not, because in this case, the Office of Administrative Hearings has already determined that the recoupments that were received by plaintiff were done correctly, and plaintiff never appealed those claims up.
But let's assume, my question is, assume the hearing, the process after the recoupment started, was adequate process, and assume it was not, the process pre-recoupment was unconstitutional. I know you disagree with that, but if those two things are both assumed, would Ms. Talley have a claim for the amount of the recoupment prior to that later hearing or that later process?
So not in federal court and not under Ex parte Young grounds. And this court in GEMSEC specifically stated that past violations are not redressable in federal court. You have to have a live, ongoing controversy.
Right. That's the injunction part. I think I get that, but I guess this goes back to maybe, the individual capacity members. In theory, there might be one for that recoupment, but that's subject to the qualified immunity analysis.
It is true that individual capacity claims are subject to qualified immunity, but also the proper way for plaintiff to challenge what she believed was wrongfully taken payments before she received post-deprivation hearing was through that Office of Administrative Hearings proceeding, and then up to the Court of Appeals in North Carolina if she still disagreed. Now it's a matter of law that these recoupments were taken appropriately. It has never been appealed, and there is nothing for this court to determine because the consequences of past violations are different from an ongoing present constitutional violation. And for purposes of Ex parte Young, you have to have a present ongoing constitutional violation to proceed. The qualified immunity also applies. I think if the court were to get to that issue, Swanson versus Powers is exactly squarely on point. Officials cannot be sued individually simply for enforcing what is very strongly presumed to be a valid state law. The
Well, this law doesn't actually require them to recoup it a certain way, right? Tally makes a valid point, right? That the state law requires the retirement system to recoup the funds, but it doesn't specify you have to recoup them without any process or without certain kinds of pre-deprivation process. But there's still the question of, is there any clearly established law putting these officials on notice that this was a violation of her constitutional rights? What's your response to her best cases that she flagged for us?
So the best cases, and it's a matter of state law, because our state courts actually have interpreted 135-9, which is your recoupment statute in North Carolina. And those state cases are Moss versus retirement system and Trejo versus retirement system, both cited in our brief. The state courts interpreted the 135-9 as having a mandatory recoupment clause, and that the retirement system is required to offset from future retirement payments any past found overpayments. That is the state law in North Carolina. So if getting back to the issue of qualified immunity, I think it really heavily favors our argument. If the law in North Carolina was that the state is required to offset, to use recoupment process, as Moss and Trejo say, then these individuals would absolutely be under no understanding that what they're doing through recoupment is violating a clearly established constitutional right.
Well, I think the argument is they should have been on notice that, yes, you can recoup or you have to, but the Constitution requires certain process before you do that. Is there a case on point for a retirement fund recoupment that would have put them on notice of that?
So not of that, exactly of opposite, which is Moss and Trejo, put them on a notice that they're required to recoup. But there is no, and then in terms of their understanding, I mean, I think the state law is very clear that what's expected of them is to follow the statute. And it's true that minimum constitutional protections do apply to the recoupment process, and we talked exhaustively about the process that was afforded to plaintiff here, both pre-deprivation and post-deprivation. So there is, under this set of facts, the board members could not have understood that they're clearly violating the established law, and no case was cited from the opposing side to show the opposite. We cited 2 state cases that show that the expectation was that the overpayments would be recouped.
So, accepting the premise that the state employees are protected when they engage in the recoupment process, is there a different part of that argument that they don't have parameters as to whether in this case they're going to take 50%, in this case they're going to take 10%, and that lack of a parameter is a separate claim, even if they're entitled to do recoupment in some form?
So, Your Honor, in this case, the position that the retirement system took was default 50%, so that the retiree still gets to keep portion of the retirement payment, and then there is a room for the retirement system to negotiate. And so the different amounts could be explained by multiple rational reasons, including that the retirees reached out to the retirement system, presented their life circumstances, and were able to receive reductions of the default 50%. That does not create, I don't think, a separate federal claim that could be cognizable under any of the principles cited in the plaintiff's claim. If anything, what that shows is that the retirement system was being flexible and was exercising appropriate discretion. And we asked the court to affirm the district court's dismissal of plaintiff's complaint on various grounds that we have discussed and that were presented in our brief.
Tell us a little bit about the district court's denial of the motion to amend, because Appellant says, well, we have other plaintiffs here. And so was the district court right or wrong on the motion to amend?
Absolutely right, Your Honor. Your standard of review is abuse of discretion. There were multiple reasons that the district court correctly cited in its decision to deny the motion to amend. It was filed many months after the court's scheduling order allowed the filing. The motion itself did not contain a good cause that was required under Rule 16. The type of interest the new plaintiffs brought, the purported plaintiffs brought, was different than the type of interest that plaintiff had here. It was contributory death benefit and disability benefit that they had. And even a different board would have to be involved. Local employees, governmental board, instead of teasers board, would have to be involved. So for all these reasons, multiple reasons, court did not abuse its discretion in denial.
All right, thank you very much.
Thank you.
All right, Ms. Bateman, you have some rebuttal time left.
Thank you, Your Honor. I've got to make this very brief in light of my going over, and I apologize for that. State law absolutely provides some authority for the fact that Ms. Talley was subject to recoupment in an amount more than she should have been. State law says that defendants are limited in actions to recover overpayments to the last 3 years of overpayments. Okay, so if they sued Ms. Talley, they could only get 3 years. If Ms. Talley sued them for underpaying her, she could only get 3 years. The defendants ignore that limitation on the amount they can collect for overpayments by resorting to the recoupment process. So the recoupment process goes back to the very beginning of any overpayment and collects it forward, resulting in hundreds of thousands of dollars of, quote, overpayments. Finally, in the Presley case, this
Let me
court...
ask you one point about the recoupment amount. Opposing counsel says that, in effect, the amount is now settled, that it's you're either collaterally estopped or a res judicata applies based on the administrative law judge's determination of the amount.
There's precedent from the United States Supreme Court that says unappealed administrative decisions have no collateral estoppel value. I can't recall the name of that case off the top of my head, but I know it's out there, and I can certainly provide a supplemental memorandum with the name of that case. But that is one of the primary reasons why we didn't appeal that case, because we didn't want there to be any collateral estoppel value in that case, given the paucity of the record. And the fact that the administrative law judge did not consider the fact that state law limits the agency's recovery to 3 years of overpayments, which they avoid by not suing, but using this recoupment process. Presley, the case decided by this court, says ordinarily pre-deprivation process is required, absent the necessity of quick action by the state or the impracticality of providing any pre-deprivation process. You have to have, and if you can't show that it's impractical or that quick action is required, a post-deprivation hearing is constitutionally inadequate.
So is that you cited that as your clearly established law when we talked before. Do you have any case dealing with recoupment of overpayment of a retirement benefit and saying that pre-deprivation process is required for that?
I believe that the Califano versus Yamazaki case by the United States Supreme Court is instructive on that issue. It talks about the United States recoupment process, and it talks about both the statutory requirements that the United States has adopted, as well as the administrative process that's in place.
Well, I'm asking about this specifically in the retirement benefits because, Matthews it's what we have and it's useful, but it's fuzzy, and you take the importance of the benefit and you weigh it against the benefits of process, and it's very circumstance specific, and I'm wondering, without a case on point for these circumstances, how are these officials to know? How is it clearly established?
Your Honor, I believe this court's opinion in Kirk versus Commissioner of the Social Security Administration deals directly with the process that's required. In that case, the Social Security Administration was dealing with widespread fraud.
So that was Social Security?
Social Security, but that's the same thing as state retirement benefits. It's recoupment. All the Social Security cases are on point, and so are the state cases that we decided that have statutes that provide for evaluation of hardship. But I will say the reason that those cases are especially important is because in 135-19, the legislature manifested its intent that the United States Social Security system be can't think of the word I'm looking for, but be the beacon by which North Carolina retirement system operates. In 135-19, the legislature declared the policy, and it says, in order to extend to employees of the state and its political subdivisions the basic protection accorded to others by the Old Age and Survivors Insurance System embodied in the Social Security Act, it is hereby declared to be the policy of the legislature, subject to the limitations of this article, that such steps be taken to provide such protection to employees of the state and local governments on as broad a basis as is permitted under applicable federal law. So all cases deciding anything related to the recoupment process under the Social Security Administration, both retirement system cases and Social Security disability cases, are applicable to this case and this retirement system and this recoupment process.
You got anything else you want to tell us?
I'm sorry, Your Honor.
Do you have anything else?
No,
want
yeah,
to
thank
tell
you, Your
us?
Honor. Thank you, and thank you for hearing this case.
Well, we thank both counsel for their arguments, and we're going to come down and greet counsel. And first, we'd ask the clerk to adjourn court for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.